Hello and welcome everybody. Thank you for participating in today's webinar on the legal requirements to ensure accessibility of emergency response programs for people with disabilities before, during, and after emergency situations. This webinar is funded by the Pennsylvania Disability Advocacy Fund, which is a fund of the Foundation for Enhancing Communities. My name is Sherry Mammis, and I'm a managing attorney at Disability Rights Pennsylvania. I'm a short, middle-aged white woman with blondish brown mid-length hair and large tortoiseshell glasses. I'm wearing a gold and black animal print shirt with a black sweater, and my background is blurred. Before we begin, I want to review a few important points on how this webinar will work. This training is being recorded and will be posted on DRP's public website for future viewing. This includes the audio for anyone dialing in by phone, as your participation in this webinar constitutes your consent to having your audio recorded. During the entire presentation, your cameras will be off and your microphones will be muted to limit background noises and other potential distractions. We will hold all questions until the end of the presentation and do our best to answer them today, but if we can't, we will follow up afterwards. If you have a question during the presentation, please enter it into the chat using the chat feature located at the top of your screen in the little text bubble. Please do not use the raise your hand feature until it is time to answer questions at the end of the presentation. DRP's contact information is included in the webinar PowerPoint, and you can contact us after the presentation if you have additional questions. The PowerPoint will be sent to the email address you used to register for today's webinar. And now it is my pleasure to introduce your speakers for today, DRP staff attorneys Rocco Iaculu and Morris Scott. Rocco obtained his JD from the Dickinson School of Law of the Pennsylvania State University and has extensive expertise in litigating and advocating on behalf of individuals with disabilities who are facing discrimination in employment, housing, government services, transportation, and public accommodations. Morris obtained his JD from St. Louis University School of Law, concentrating in healthcare law, and is an experienced litigator in the areas of real estate law, landlord-tenant law, bankruptcy law, and default litigation. His areas of expertise at Disability Rights Pennsylvania include discrimination in employment, housing, public accommodations, and public schools. And now I'm turning it over to Morris to begin our presentation.
Thanks, Sherry, and hello to everyone. Let me begin with a brief description of myself. I am a middle-aged African-American male with no hair by choice. I am sitting in my office. There are plants in the background, artificial plants. I am wearing glasses, and I am also wearing a white button-down shirt. With that, let's begin with talking about Disability Rights Pennsylvania. On slide 2, please. So, what's Disability Rights Pennsylvania? Who are we? For those who may not be aware, Disability Rights Pennsylvania, or DRP, is an independent, statewide, nonprofit corporation designated as the federally mandated protection and advocacy, or the PNA, agency in Pennsylvania. DRP protects and advocates for rights of people with disabilities so that they can live the lives they choose, free from abuse, free from neglect, free from discrimination, and of course, free from segregation. With that, let's begin with an overview of what we will present in this webinar. Slide 3, please. And so this is just a brief outline of what we will cover, some takeaways that we hope that you will have at the end. We're going to learn about the unique needs of people with disabilities during various types of public emergencies. We're going to learn about the federal legal rights of people with disabilities to have equal access to state, county, and local government emergency program services and activities. Yes, emergency preparedness and planning is an issue that includes every level of government. We're also going to learn about critical information that can help persons with disabilities respond to and to be prepared for an emergency. I notice that we are concerned with issues that relate to the time period before, during, and after a public emergency. We're also going to learn about self-advocacy tips that will help individuals with disabilities to advocate for their rights. Next slide, please, slide 4. To place this webinar in actual real-life context, some of the examples of emergencies can be public health emergencies, for example, the COVID-19 pandemic. Other examples, natural disasters, a flood, an earthquake, a hurricane, a tornado, or other severe weather events. Examples of other emergencies, hazards such as an environmental disaster or a train derailment, or even a large fire. Another example could be a mass shooting or other mass casualty type events. Now, of course, our world has witnessed many, if not all, of these emergencies in recent times, so this webinar is certainly relevant. And so with that, I'll turn it over to Rocco for the next section.
Yes, and before I begin, I will provide a description of myself. I am a middle-aged white man who is wearing reading glasses today. I do have a beard. I am wearing a button-down light blue Oxford dress shirt, and my background is blurred as I am working remotely today. I'm going to take over for a little bit here and first start with providing a general overview of the federal civil rights laws that cover and may apply to people with disabilities' rights to equal access to emergency preparedness programs and services, including discussing the application of these laws, who they cover, and then getting into the specific rights, protections, and affirmative obligations that they provide for people with disabilities. As you see the list here, we'll be discussing Section 504 of the Rehabilitation Act, and then Title II of the ADA, Title III of the ADA, the Fair Housing Act, and then Section 1557 of the Patient Protection and Affordable Care Act. So the Section 504 of the Rehabilitation Act is the law that was the antecedent to the ADA, which was passed in 1973, and it prohibits disability-based discrimination by all state and local government programs or any private entity which receives federal financial assistance. So this could include governmental agencies as well. On the state and local level, it can apply to school districts, but again, it can even apply to private entities that receive federal funding, such as hospitals or other medical type facilities as well. The Section 504 prohibitions on discrimination are construed consistently with the Americans with Disabilities Act. And so a lot of times today we will be referencing mostly the ADA. And again, the courts have held that Section 504 should be interpreted consistently with the ADA. So the Patient Protection and Affordable Care Act, also known as Obamacare to most of us, I think now, actually has its own prohibitions on discrimination in healthcare related programs and activities. And again, the provisions of the Affordable Care Act will be generally interpreted consistently with Section 504 in the ADA in terms of determining what type of conduct is considered discriminatory. And again, in the event of emergencies, when you're dealing with public health emergencies, this statute is one that would apply to prevent or prohibit disability-based discrimination. So Title II of the ADA applies to all public entities, which include state, county, and local governments, and any department, agency, special purpose district, or other instrumentality. So again, school districts would be covered by, public school districts would be covered by Title II of the ADA. And Title II applies to all of the programs, activities, and services that are provided by those entities, and including their emergency program services or activities. On the other hand, Title III of the ADA applies to what the law calls places of public accommodation. And this applies to anyone that owns, leases to, or operates any place of public accommodation. The law provides 12 broad categories of places of public accommodations that the entity must fall within to be covered by Title III. I have provided a list of some of those categories here in our presentation that may most likely be involved in emergencies or emergency response. So you can see here places of lodging, the professional office of a healthcare provider, hospital, or other service establishment, terminal, depot, or other station used for specified public transportation, all types of schools, daycare centers, senior citizen centers, homeless shelters, or other social service center establishment. So in the event of an emergency, if shelters have to be open to have people evacuated to, those shelters would be covered by Title III of the ADA if they are owned or operated by a private entity. If they are owned or operated by a state or local government, then they would be covered by Title II of the ADA. So I have a slide here just providing an overview of the rights and protections afforded to people with disabilities under the ADA. So Congress intended the Americans with Disabilities Act to be a broad remedial statute. In the statute itself, Congress specifically made this clear by stating the purpose of the ADA was to provide a clear and comprehensive national mandate for the elimination of discrimination against individuals with disabilities. And as you can see through this list of key protections and rights, Congress was not only focused on intentional discrimination, but also the discriminatory effects of architectural, transportation, and communication barriers, overprotective rules and policies, the failure to make modifications to existing facilities and practices, the presence of exclusionary qualification standards and criteria, segregation, and the relegation to lesser services, programs, and activities. So you can see here obvious prohibitions on discrimination, such as outright denial of access to full and equal enjoyment of programs, services, activities of a public entity or the goods or services of a place of public accommodation, providing unequal treatment to people with disabilities, but then some of these affirmative obligations, Both Title II entities and Title III entities have an obligation to make reasonable modifications in policies, practices, and procedures to ensure equal access. They also are required to ensure effective communication with people with disabilities, including the provision of auxiliary aids and services. Also, under Title II of the ADA, public entities are responsible to make sure that their programs are accessible to people with disabilities and that people with disabilities are not denied access to services because their facilities are inaccessible. Likewise, albeit somewhat different, under Title III of the ADA, public accommodations have an obligation to remove architectural barriers when readily achievable. But under both Title II and Title III of the ADA, all newly constructed or altered facilities must be built so that they are readily accessible and usable by people with disabilities. Again, I will discuss a little bit more, and you will see how these provisions apply to emergency preparedness programs. Finally, I'm also providing an overview of the Fair Housing Act, which may also apply to some emergency shelters or temporary housing. Again, typically the Fair Housing Act would apply to what people understand to be traditional housing, but some emergency shelters or temporary housing could fall within coverage of the Fair Housing Act if individuals remain for some significant period of time, which might be as short as a few weeks. The Fair Housing Act bars owners or renters of dwellings from discriminating against people with disabilities. So that includes refusing to rent to individuals with disabilities, making a dwelling unavailable, setting different terms or conditions for the rental or use of housing, or providing different services or facilities. Again, under the Fair Housing Act, a covered entity would also be required to provide reasonable accommodations in rules, policies, or practices when necessary to afford a person with a disability an equal opportunity to use and enjoy a dwelling. So this is a very important slide, and I think is the main focus of our presentation today, is that governmental emergency preparedness programs must be accessible to people with disabilities. The United States Department of Justice, who is the federal agency that enforces the ADA and has adopted the implementing regulations to enforce the ADA, have made this clear in their materials on their website. On the slide, you can see a reference to some of those materials. The Department of Justice has a few guidance documents with regards to providing guidance to state and local governments on their obligations under the ADA to ensure that their emergency preparedness programs are accessible, including a best practices toolkit. But there have even been some court cases around this topic that have also made it clear that the ADA requires state and local governments to ensure that they are providing equal access in their emergency preparedness programs. The first case that is cited here, Brooklyn Center for Independence versus Bloomberg, was a case that was brought by disability advocacy organizations and several disabled plaintiffs against this New York City. After the court ultimately ruled in this case based upon findings presented by the plaintiffs that New York City violated the Americans with Disabilities and the Rehabilitation Act because its emergency evacuation plans did not accommodate the needs of people with disabilities with respect to high-rise evacuation and accessible transportation. Their plans failed to provide sufficiently accessible shelters, both architecturally and programmatically. Their plans failed to sufficiently inform people with disabilities of the availability and location of accessible emergency services. And their plans failed to provide advanced information on accessible evacuation centers or transportation. The court held that this particular issue violated the ADA because it deprived people with disabilities of an equal opportunity to plan in advance for an emergency, as opposed to those without disabilities were able to sufficiently plan ahead, but due to the lack of information sharing with people with disabilities about accessibility issues, accessible services, that again, the court found that that was unequal treatment in violation of the ADA and the Rehabilitation Act. The second case listed here, Communities Actively Living Independent and Free versus the City of Los Angeles, was another court case brought by disability advocacy groups and disabled plaintiffs, again alleging that the City and County of Los Angeles failed to provide meaningful access to the city's emergency preparedness program. Again, the court ruled in favor of the plaintiffs on at least some of their claims by finding that the city's plans did not include provisions to notify people with auditory impairments or cognitive disabilities. There were no plans to evacuate, transport, or temporarily house individuals with disabilities during or after an emergency. The city did not know which, if any, of its shelters were architecturally accessible, and did not know if the shelters could accommodate people with special needs. And because the city failed to address their unique needs, the court found that individuals with disabilities were disproportionately vulnerable to harm in the event of an emergency or disaster. So it's clear both from the United States Department of Justice and at least two court cases that not only is it critical that state and local governments ensure accessibility to their emergency programs, but it's a legal requirement under the ADA and the Rehabilitation Act. So the importance of accessible emergency programs and plans, I think, is very clear. It's one of the most important functions of government is to protect their citizens or residents from harm, including helping people prepare for and respond to emergencies. It's imperative that people be able to plan ahead and that those plans address the particular needs of people with disabilities. Otherwise, when an emergency happens, things are going to go poorly and people with disabilities will be harmed. The fact is that persons with disabilities oftentimes face unique barriers in emergencies, and unfortunately, their needs are often overlooked in emergency planning. And again, this will lead to disproportionate harm to people with disabilities. So today we are going to focus on 4 key elements or components of accessible emergency plans and programs. The scope of emergency planning is obviously extremely broad and can encompass a variety of elements. And we are likely not going to be able to address all of those here today, but we do want to focus on these 4 key areas, which include accessible and effective emergency evacuation plans, accessible and effective notifications and communications, equal access to shelter facilities and services, and equal access to health care, social services, and recovery. So the emergency planning process is key to ensuring that people with disabilities' needs and barriers are addressed. So because emergencies are unpredictable and can happen at any time, advanced planning, ensuring that you have resources available to execute those plans, and a willingness to update and revise plans that do not work, it is critical. And so one way that state and local governments can ensure that the needs of people with disabilities are met is to solicit input from people with a variety of disabilities, disability advocates, and other disability experts, and to rely on them in developing and updating emergency plans with respect to all phases of emergency management. Even the Department of Justice had a suggestion on their website that I found very interesting. The Department of Justice suggested that state and local governments should enlist people with disabilities to role play during emergency simulations. I think that would also be a good recommendation, but definitely soliciting the input from a variety of people with disabilities is the only way to ensure that all of those needs will be addressed. Another type of option in terms of advanced planning that I may also talk a little bit more about later as well is developing registries of individuals with disabilities that can be used to identify, for instance, folks with disabilities who are working in high-rise buildings. You could develop a registry, and as long as it's voluntary and confidential, that might be an acceptable advanced planning tool to use, whereby a list of people with disabilities can be put together so that in the event of a fire or other emergency, that the local EMS, fire department, etc., could develop a plan to evacuate those individuals and provide the individual assistance that they need. And again, obviously, to be effective, it would have to be publicized. And again, it would have to be voluntary and kept confidential. But that could be one tool, again, in advanced planning that could ensure accessibility for people with disabilities. It is also imperative to plan for the evacuation needs of people with disabilities. Again, people with physical disabilities or other disabilities face unique challenges in evacuating for disasters and emergencies. So people with mobility disabilities may need assistance leaving a building without a working elevator in the event of a fire or other emergency. They may need the assistance of mobility devices such as wheelchairs, canes, or walkers. People who are blind or have low vision may not be able to, navigate on their own in the event of an emergency. They may need to rely upon individuals to help them evacuate buildings safely. Even individuals who are deaf could become trapped and would be unable to communicate with emergency response if the only way to communicate is through voice. So again, there are a variety of unique challenges that people with disabilities face, and to be providing meaningful access to emergency preparedness programs, these needs need to be addressed. In terms of accessible evacuation planning, it is important, again, that public entities have plans in place ahead of time to ensure that people with disabilities can be evacuated from their homes, their jobs, or other locations. Such plans should include identifying accessible transportation for individuals with disabilities. For example, lift-equipped vehicles to be used to evacuate people with mobility devices or people with mobility disabilities. Again, in the New York City court case that I referenced earlier, this was a big problem that the court found, that the city failed to have a plan to provide accessible transportation to people with disabilities to evacuate in an emergency. In essence, the city said that people could rely upon public transit to evacuate. And the court said that, leaving aside the fact that there are many stations in New York that are not physically accessible to people with disabilities, that was not sufficient to address the needs of people with disabilities in an evacuation. The court found that the city needed to have a plan to both identify accessible transportation options and publicize that information to the disability community. Other types of assistance that should be included in evacuation plans are plans to ensure individualized assistance for evacuation of people with disabilities and any equipment or supplies that they may need. People with pulmonary conditions may need portable oxygen, and that's going to be critical for them to be able to keep that with them. But even bringing communication devices as well and other assistive technology devices, and also ensuring that people with disabilities are informed about their right to reasonable accommodations. For example, being allowed to keep their service animal with them, which would be their right under both the ADA and the Rehabilitation Act. Again, just this slide, some more information on voluntary registries. Again, just reiterating that these registries are permissible as long as public entities ensure that they are voluntary, confidentiality is protected, and the information is updated as needed. An important point to make here, though, is that voluntary registries alone will not be enough to ensure that the needs of people with disabilities are met. There must be policies and practices in place to utilize the registries appropriately and effectively. So, if you have a registry and you say, well, we're just going to hand that to the fire department in the event of a fire, but we're not really sure what they're going to do with that registry, then obviously that's not sufficient. The fire department needs to have a plan to state how they were going to evacuate those individuals that are on the registry. So again, just having the registry alone is not going to be sufficient to comply with the law, but it would be one tool in the toolbox that could be used potentially to make sure that the needs of people with disabilities are met in evacuations in the event of an emergency. The next key component that I'm going to run through before I hand things back over to Morris is with regards to effective notifications and communications. And this is going to be critical both before, during, and after emergencies. The effective notifications and communications need to take into consideration the different needs of hearing, vision, and sensory disabilities. I will provide some examples and an overview of some necessary communication and notification methods that should be used in the event of an emergency. And then finally, there is a slide that I will review on some of the current government emergency alert systems that are currently available, that are accessible to people with disabilities, and could be key to helping you plan for an emergency. So effective communication is obviously critical in an emergency. People facing emergency situations, whether it's a natural disaster, man-made disaster, health disaster, or mass violence, obviously depend on current and accurate information to make the correct decisions about how to protect their health, welfare, and safety. However, people with disabilities face communication barriers that in emergency situations can place them in jeopardy because many traditional emergency notification methods are not accessible to them. So warning methods should be developed that address these communication barriers. And here is just some examples of those barriers that people with disabilities might face. So people who are deaf or hard of hearing cannot hear sirens or other audible alerts or spoken language on television, radio, or the internet. People who are blind or have low vision cannot see visual cues such as flashing lights. And people with cognitive disabilities may have difficulty comprehending information that is not presented in plain language. So not only, again, is it critical to provide effective communication to people with disabilities, but it is a legal requirement under the ADA and the Rehabilitation Act. Both laws require the public entities to ensure that emergency notification methods and systems they use are accessible to people with visual, hearing, and sensory disabilities, and they must ensure that they provide effective communication to people with a variety of disabilities. Under the law, failure to provide effective communication is discriminatory because it can lead to a denial of meaningful or equal access to a government's emergency preparedness programs, services, or activities. And under both Title II and Title III of the ADA, with some slight differences, both provisions require the provision of appropriate auxiliary aids and services when necessary to ensure equal access to people with disabilities. Auxiliary aids and services are defined very broadly in the law, and there are some examples listed on this slide in relation to emergency situations that absolutely would be covered within that list of required auxiliary aids and services. So prior to emergencies, public entities must provide written and online materials on emergency plans, such as information on shelter availability, transportation options, and information on post-emergency benefits and services in accessible formats. So that could mean providing written materials in Braille or large print, or on electronic disc or other audio format for people who are blind or have limited vision. Ensuring that online information is usable by screen readers that people who are blind use. Ensuring that online information is presented by a qualified sign language interpreter and captioned so that it is accessible to those who are deaf or hard of hearing. Then obviously not only before emergencies, but during emergencies and notification of an actual emergency that is occurring is even more critical to ensuring that people with disabilities have the ability to plan and for emergencies and to determine how to respond. Public entities should use a combination of emergency notification methods to meet the communication needs for people with a variety of disabilities. So this should include combining visual and audible alerts to reach individuals with hearing and visual impairments, using qualified sign language interpreters and open captioning for announcements and communications. We often see, although it's not an emergency that we typically deal with in Pennsylvania, but people see the news from hurricane response, and there have been other emergencies, in large cities like New York and Philadelphia, where the local mayor comes out, holds a press conference about an emergency to provide status updates and to provide critical information. And hopefully now, I believe that I'm correct, that oftentimes I do see an interpreter who is on the stage, who is interpreting the information for people who are deaf, but also providing captioning for those press conferences. Those are things that are required by the law to ensure effective communication. It can also include other things such as auto dial text telephone messages to pre-registered individuals who are deaf or hard of hearing, text messaging, emails, and other innovative technologies for emergency notifications. And again, finally, to make sure that people with cognitive or intellectual disabilities are being accommodated, it's imperative to ensure that any written or oral communications to the public are delivered in plain language. There is also an obligation to provide effective communication in shelters if people are required to evacuate during an emergency. So public entities, in coordination with any public accommodations who are operating any shelters, or in coordination with other organizations like the American Red Cross or others, should establish policies and procedures to ensure effective communication with people with disabilities while staying in shelters. That includes having a plan to provide auxiliary aids and services when necessary. Providing written materials in alternative formats in plain language, providing information to deaf people using a qualified sign language interpreter, and providing assistance to people with cognitive or psychiatric disabilities that can help them understand information, complete necessary forms, and navigate service systems. So I've been talking a lot about what public entities are required to do. So we thought we would throw a slide in here to just talk about some potential limits on the right to effective communication during an emergency. So under the law, public entities are not required to take any actions that would result in a fundamental alteration or undue financial or administrative burden. Although I will point out that this is a very high standard, and it may just be my disability advocate side speaking here, would say that it would generally be a rare situation where a particular auxiliary aid or service would constitute an undue burden, just in light of the fact of the available resources that state and local governments usually have to pay for and to provide auxiliary aids and services. So again, it is going to be a pretty high bar to meet that defense or to be subject to that limit. There is, generally speaking, limits on when public accommodations or public entities can require, and in fact, I'll just state it, generally speaking, public entities and public accommodations cannot require someone who is deaf, for instance, to bring someone with them to interpret. and are generally not allowed to rely on an accompanying adult to interpret or rely on a minor child to interpret, except in an emergency involving an imminent threat to the safety or welfare of an individual or the public where there is no interpreter available. So again, if there is a sudden emergency, and there is just simply no one else around to interpret, and let's say police are trying to evacuate individuals to try to get them to safety, and there's just no other choice in order to communicate with the individual, that probably would be acceptable in that situation, to use a family member to interpret for that individual. Finally, there also is an allowance of using video remote interpreting, if the remote interpreting meets 4 specific conditions regarding ensuring that real-time full motion video and audio can be provided over a dedicated high-speed wide bandwidth, that it can provide sharp image and large enough image to encompass interpreters and the participants' face, arms, hands, and fingers. If it provides clear audible transmission of voices, and that the operator is trained in the use of video remote interpreting. So again, that might be something, for instance, that can be used in a shelter, in specific situations. Again, the bottom line is the communication method must be effective. So you do need to look to the individual. For some individuals, video remote interpreting still may not be effective for them, and you would have to use an alternative. So again, it's important to plan for all of these issues in advance, and to be able to plan for a variety of people with disabilities and a variety of needs. Finally, here and also later in the PowerPoint slides in our resources section, I believe there's additional information as well. But I just wanted to talk to speak to some of the alert systems that are already in place, that are in fact accessible to people with disabilities. And you can find these basically on the state level, and as well as through many of the local counties here in Pennsylvania. They are called the Ready Alert Systems. And in essence, county residents can sign up to receive notifications about emergencies, disasters, and community information. And those notifications are provided in various formats, including text messages, emails, voice calls, and mobile app alerts. So when you go in to sign up for the app, you can choose your desired communication method. And again, I think most of these systems provide accessible means of notification for people with many types of disabilities. Again, on the state level, it's called Ready PA, and it's their emergency alert system. And then on the federal level, under the Federal Emergency Management Agency, there is a federal notification system that is called IPAWS, that you can also sign up for, that provides emergency alerts in a variety of formats. So I'm going to stop there and hand things back over to Morris to cover the next 2 key components of emergency preparedness programs.
Thanks, Rocco. So let's now look at the subject of equal access to shelter facilities and services during an emergency. Under this subject, we're going to cover the subtopics of accessible shelters and facilities, eligibility criteria, integrated settings, service animals, and emotional support animals. There is a difference. Reasonable modifications and accommodations, Also, assistance with evacuation from shelters. That's a good topic there to talk about. And then also assistance to transition from shelters, whether it's transitioning back to one's original home or transitioning to find temporary housing if the original home is not available. Let's move to the next slide, and let's now deal with accessible shelters and facilities. The first issue deals with the choice of a facility for a shelter. And it's important to understand that inaccessible buildings should not be chosen for shelters or temporary housing. Inaccessible buildings, if they're inaccessible, they should not be chosen for shelters or temporary housing. And there are reasons for this. If this happens, it's going to inevitably lead to the denial of access to persons with disabilities or discrimination, some kind of discrimination against them once they enter. Another point to understand about accessible shelters and facilities is that emergency plans they must ensure that there are sufficient accessible shelters and temporary housing for people with disabilities. Considerations have to be given to, for example, those with mobility issues, mobility disabilities. Another point about accessible shelters and facilities is that emergency plans have to ensure the provision of electricity in the event of a power failure. So if there's a power failure, there must be a plan in place that's going to ensure that some kind of power, some type of electricity will be provided. Examples of this includes a backup power generator. Now, why is this important? Because power is relied upon by persons with disabilities for electricity to power things like mobility devices, communication devices, or life-preserving equipment, things like oxygen, breathing devices, and refrigeration for necessary medication. So remember now, these are not optional items, but these are necessities. These are life-preserving necessities. So let's move to the next slide now, and let's talk about eligibility criteria, integrated settings. So what's the issue here? The issue really is who gets in and what kind of shelter are they allowed to enter. The ADA and the RA, the Rehabilitation Act, prohibit the imposition of eligibility criteria that screen out or tend to screen out people based upon disability, or if it has the effect of screening out people based on disability, unless, there's a very narrow unless it can be shown that the criteria is necessary, the criteria are necessary. Shelters are grouped into two categories. You have mass care shelters, and you also have medical care shelters, which serve people with higher medical needs. Mass care, of course, now would provide greater integration with family members. So services must be provided, and this is a very important point. Services must be provided in the most integrated settings appropriate to meet the needs of the individuals with disabilities. People with disabilities should generally be allowed to use mass care shelters so they can be housed with their families, friends, neighbors, and non-disabled people rather than be forced to use medical shelters. And mass shelters must provide accommodations and resources to support the people with disabilities. Let's move now to the next slide, and let's talk about service animals and emotional support animals. The issue of service animals and ESAs, emotional support animals, is a very important one with respect to sheltering. The ADA and the RA generally require that shelters allow people with disabilities to have service animals with them. This is the case even if they have a policy of disallowing pets. And the reason why is because service animals are not considered pets. The modification of a no pet policy would be necessary. It would be a necessary, reasonable modification. And listen, you'd be surprised how many individuals, how many businesses, how many housing providers don't realize that service animals are not pets. So service animals under the ADA are limited to dogs and in some cases miniature horses, and they have to be individually trained now to help a person with a disability to address their disability. And you can access the DRP resource page on our website for more information on details about a service animal, what really constitutes a service animals. There are regulations and case law on the subject as well. So now it's important to know that the ADA and the RA do not protect ESAs or emotional support animals. But as we heard before in this presentation, the FHA does provide some protection for ESAs. And so if a shelter or housing is considered a dwelling, then the FHA now would apply and would require the allowance of the ESA, the emotional support animals. Let's move now to the next slide, and let's talk about reasonable modifications and accommodations with respect to shelters. The ADA and the RA require public entities to make other changes to policies, practices, or procedures at shelters that people with disabilities need. So requests can be made for reasonable accommodations or modifications. Now, what are some examples of reasonable modifications or accommodations in shelters? It may include, for example, access to a quiet space for individuals whose disabilities, for example, autism, might require limited distractions. Another example is a provision of firmer or elevated sleeping surfaces than mats on the floor. Another example could include changes in policies and restrict times for access to food for people with diabetes, for example. Another example is something like a provision of assistance with completion of necessary forms and applications for individuals that might have cognitive or psychiatric disabilities, so just providing assistance in completing the necessary forms. Again, individuals with disabilities should not be reluctant to make a request for reasonable accommodation or modification. And once that request is made, there must be a response in some form or fashion. It cannot be ignored, but it all starts with making that request for a reasonable accommodation or modification. Next slide, let's talk now about assistance with evacuation from shelters. So the issue is, what if there is another emergency or circumstance which requires the evacuation from the shelter itself? How should that now be effectuated? Well, it starts with having a plan. Having a plan. Shelters should have a process in place which facilitates an efficient and safe evacuation, which takes into consideration the needs of people with disabilities, which ensures effective communication. We talked about that before. Ensures effective communication about the process to shelter residents with visual, hearing, and cognitive disabilities. And also a process in place which includes accessible transportation available to those with mobility disabilities or with special medical needs. So now let's move to the next slide and let's talk about assistance to transition from shelters and to find temporary housing. So what about when it's time to transition from the shelter in order to find housing or temporary housing? If individuals with disabilities cannot safely return home and must relocate, they might have difficulty locating temporary housing. And so public entities must ensure that people with disabilities, that they have equal access to temporary housing. Some examples of this assistance might include helping those with visual disabilities who may not be able to independently travel to identify and visit housing options, or even something like providing accessible transportation to enable individuals with mobility disabilities to visit temporary housing options. But this is important now, that there can be direct or even indirect pressure upon persons with disabilities to enter institutionalized places of care. But people who can live independently should not, and I repeat, should not be pressured by the shelter to go to hospitals, nursing homes, or other institutions. There's information at the end of the presentation on how to locate a shelter or temporary lodging during a public emergency. You know, we alluded to it before, but information can be found, for example, by calling 211, Pennsylvania's hotline, to assist with a number of services, or visiting pa211.org, or visiting the Red Cross's website, which allows actually for searches for open shelters, or even by downloading their app. And I believe FEMA also has an app as well. So let's now move to another major subject. Next slide. Let's talk about equal access to healthcare, social services, and recovery. The subtopics that we're going to cover under this general topic are number one, non-discrimination in healthcare, social services, and recovery. We're also going to talk about healthcare rationing. That's a big issue. And then we're also going to talk about reasonable modifications and accommodations. We're going to say a little bit more about that. And then also about accessibility. Now, I'm not going to say too much about the non-discrimination, because the general topic of the laws and regulations against discrimination have already been covered. But it has to be understood that those laws and those regulations are certainly applicable to the provision of healthcare and social services to persons with disabilities. With that, let's now talk about one of the ways that discrimination can actually occur. And let's move to the slide on healthcare rationing. It's important to understand that during an emergency, when there is high demand for healthcare services and limited resources, there may be efforts, and sometimes the efforts can be direct or sometimes it can be indirect, to deny resources to people with disabilities based on stereotypes or based on perceptions about their quality of life. And those efforts, those actions are discriminatory. That conduct violates the law. Persons with disabilities have a right to receive health care, and persons with disabilities cannot be denied treatment because of their disabilities. So you might ask, well, how then should decisions about treatment be made? They should be made based upon the individual assessments and objective medical judgments. That's how the decision should be made. But categorical exclusions based on disability cannot be used to allocate healthcare. Healthcare providers cannot make allocation decisions based upon their perceived life expectancy or quality of life. That cannot be done. Let's move to the next slide, and let's talk now about reasonable modification and accommodations in healthcare services. Providers of healthcare, social services, and recovery services are required to make reasonable modifications to allow individuals with disabilities to access their programs, benefits, and services. This is not an option, this is not a choice, but it is a requirement. So what are some examples of required modifications? Allowing individuals with disabilities to be accompanied by their service animals, that's one. Adjusting how services are even delivered. An example of this would be offering vaccines in the home of a person with a disability who is unable to travel because of their disability. Another example of required modification could be modifying restrictions on the visitation for individuals. If there's a restriction on the visitation for individuals with disabilities who require assistance to communicate or function due to personal care needs or behavioral issues. And so if an individual with disability actually requires assistance to communicate or to function, that's an example of a modification that should be made. So let's move now into or to the next slide, the accessibility of healthcare or social services. As we said before, the anti-discriminatory laws apply to the provision of healthcare, including the issues of accessibility. Providers of healthcare, social services, and recovery services have to ensure that their programs are accessible to people with disabilities. So sites should be physically accessible to people that, for example, have mobility disabilities. Or if they can't be made accessible, then some kind of alternative should be offered so that people with disabilities can successfully access the program. So let's move now to the next general topic. We've heard about rights and so forth. How do we now advocate for our rights? Let's talk about the general subject of advocating for our rights. The question is, what measures should I take in order to enforce my rights during an emergency, especially when a dispute arises? And we're just going to give you some key self-advocacy tips. And the first one is one that might seem very obvious, but it's very important, and it's dialogue. It's dialogue. Sometimes there's a misunderstanding that can be resolved by simply coming together and simply talking, speaking with the program representative, speaking with the employer, speaking with the emergency management coordinator about your concerns or about whatever the need is. Requesting information on evacuation plans, shelter facilities, reasonable accommodation policies, and so forth. Another tip, and again, this might seem very obvious, but it's one that a lot of times is ignored, is to document. Document, document, document. The failure to do this is one of the most common mistakes that people make. In the heat of the battle, it's so easy to forget to keep a record of conversations, of transactions. Document interactions, including reasonable accommodation requests. Keep copies of correspondence, emails, or other papers. Now, you might say, well, in emergency, what if I don't have a pen? What if I don't have a paper on me? Well, any way that you can find to document it, even if it means taking out the cell phone and taking a picture of whatever the piece of paper is that you wrote on, or the request that you made. There might not be a copying machine nearby, but you can take a picture of it with the cell phone, and that will preserve the interaction. Another tip is to contact advocacy and legal organizations. Of course, Disability Rights Pennsylvania is available, but there are a host of many other advocacy and legal organizations that are available to provide information, to provide guidance, and even referrals if they can't handle the issue. Let's move now to the next slide now. Let's talk about actually enforcing your rights. So the question is, what happens if mere dialogue is not successful? Sometimes people won't respond appropriately to mere words. In such a case, further enforcement of your rights might be necessary. So options include, for example, filing administrative complaints. For ADA and Section 504 of the Rehabilitation Act issues, a United States Department of Justice, DOJ, complaint can be filed. Remember the applicable statutes of limitations, 180 days for the OCR complaints. For housing issues, Fair Housing Act violations, a U.S. Department of Housing and Urban Development, HUD complaint can be filed. Also remember the applicable statute of limitations. I believe it must be filed within 1 year of the date of discrimination. And for something like healthcare discrimination, those complaints, or if there's discrimination under Section 504 or the PACA, the Affordable Care Act, the complaint can be filed with the U.S. Department of Health and Human Services, HHS. The Office of Civil Rights Complaint, OCR complaint, can be filed. Of course, remember the statute of limitation restrictions as well, 180-day. And also, don't forget that FEMA also has a very basic way of communicating with them, a please contact us site where complaints can be lodged as well. So let's move now to the next slide. Let's talk about the more intense enforcement of rights, filing a judicial lawsuit. Of course, you do have the right to file a complaint in federal court if you think that your rights under Title II or under Title III of the ADA or Section 504 of the RA or the FHA have been violated. You are not required to file an administrative complaint before doing so. In Pennsylvania, such complaints must be filed within 2 years of the discriminatory actions, even if administrative complaints are pending. And so it's important to remember those points of enforcement of rights. The next slide just shows very quickly the information and resources that are available, a host of valuable information and resources and contacts under the FEMA, the Federal Emergency Management Agency. You have the Office of Equal Rights, and the information is there. You also have the Civil Rights Resource Line. You also have the FEMA Guidance on Integration of Functional Needs Support Services in General Population Shelters, and there's a website for that information as well. The next slide shows some state resources. You have the PEMA, the Pennsylvania Emergency Management Agency, the lead agency that's responsible for coordinating emergency preparedness, response, and recovery. You have that information there. You have Pennsylvania Emergency Preparation Guide and Alert System that can be found at ready.pa.gov. We alluded to that before. And you also have the Pennsylvania Department of Human Services, DHS. This agency coordinates the Commonwealth's response to disaster-caused human needs, including disability-related needs, and coordinates the mass care social services, such as the provision of food, shelter, and supplies. This is a very important agency to be aware of. And so the next slide just talks about, we alluded to it before, the shelters, temporary lodging resources, calling 211, Pennsylvania's hotline, to assist with an array of services, or actually visiting the Pennsylvania 211 website, which is pa211.org. Of course, visiting the Red Cross's website, which actually allows you to look for open shelters, and then also downloading the Red Cross's emergency app. The next slide of local resources shows that each Pennsylvania county has an emergency management coordinator, an EMC, who can be contacted for information during an emergency. And you can find a listing. They actually have a listing of each county's EMC at the website pa.gov. So for immediate attention to any urgent individual medical needs, of course, you dial 911 to access the local emergency assistance providers. And so we certainly don't want to stop without mentioning the DRP resources. We have several fact sheets on the rights of people with disabilities in an emergency situation. The evacuation plan, inclusion and accessibility is one of those fact sheets. We also have another fact sheet on effective notification and communication for people with disabilities. We have another one on access to shelter and temporary housing. And then finally, we have another one on access to healthcare, social services, and recovery services. So we've talked about a lot of these, touched on a lot of these issues in this presentation, but the fact sheet has further details and resources as well. And of course, if you'd like to contact us, our contact information is certainly here on the next slide. So with that, I believe we can open up the webinar to any questions that might be there.
Thank you, Rocco and Morris, for a wonderful presentation. And just to follow up on the last slide there about our contact information, Disability Rights Pennsylvania operates an intake helpline. So you can call us Monday through Friday between 9 a.m. and 3 p.m. if you'd like to try to talk to a person live. If you call outside of those hours, you'll go into our voicemail. You'll still get a call back from a live person. So you can contact us at any time if you have a question about emergency preparedness with regard to a person with a disability or any other issue that you may have concerning a person with a disability. Either you can call as yourself as a person with a disability, or we also talk to other interested persons that are looking for information, advice, and referrals for those sorts of issues. Okay, I don't see any questions in the chat. If anyone has a question, you can feel free to put it in the chat now, or if you cannot or prefer not to use the chat feature, you can use the raise your hand feature, which is at the top of your screen. It's the little hand icon with the word raise written underneath of it. And if anyone is just participating by phone, so you've just dialed in, if you hit *5 on your phone, that will trigger the raise your hand button. So we'll pause for a moment just to see if anybody has any questions. And of course, if you think of any questions after we conclude the webinar today, again, feel free to reach out to us, call our intake number, or send us an email at that intake@disabilityrightspa.org address, and we can follow up with you regarding any questions that you have. All right, I'm not seeing any questions in the chat, or I'm not seeing anybody who's raised their hand. So with that, I think we can conclude today's webinar. Again, thank you very much for your participation. And just to reiterate that this webinar was actually made possible through the Pennsylvania Disability Advocacy Fund, which is a fund of the Foundation for Enhancing Communities. So we would like to again thank the foundation for their support to make this possible. Thank you, everyone, and have a great rest of your week.